And good morning, everyone. So we're going to be looking now at some of the issues that are likely to be coming across our desks in 2021 and beyond. If it was not enough coping with COVID, SIGA, and deciding which set of in-laws, if any, to have in your Christmas bubble, the government has kindly given us some further matters to get our teeth into. David joined Radcliffe this year, and we're very pleased to welcome him. I was slightly concerned to see on the website, though, that he's described by the directories as a silk who gets his hands dirty. David, I'm not sure that's very COVID compliant. Katie was called in 2013 and is already ranked in Chambers and Partners in the Legal 500 as a rising star. And for fun, she edits Atkins court forms on bankruptcy. Alison, who I hope will now turn her camera on. Thank you, Alison. Is a very experienced partner at Norton Fulbright. Recent experience includes the HMV administration. Particularly important that she is now the chair of the R3 Back to Business, and that gives her a key role in working with the government and industry in these unprecedented times. And I'm sure she'll share the benefit of that experience with us. And last, but by no means least, Andrew Bailey, very experienced insolvency practitioner at Turpin, Baker and Armstrong, and will no doubt have some interesting views on acting, or not acting as the case may be, as a monitor, and the new concept which we must get on top of, an evaluator. Now, first topic we're going to cover, the last time we had to worry about this was in 2003. Man United had won the title, Tony Blair, yes, remember him, he was Prime Minister, and England were World Cup rugby champions. Yes, in the middle of the pandemic, it's time to bring back Crown preference. David, what are we talking about here? Why is Crown preference coming back and what's it going to involve?
Thanks, James. Yes, removed by the Enterprise Act 2002 and now 17 years later, making a reappearance in a slightly modified form. Really it's taxes that are collected indirectly. So things like VAT and amounts deducted at source, if you like, it would be passed on. So PAYE, employees, national insurance, construction scheme deductions, they are now going to regain preferential status. Things that are collected directly, so your corporation tax, employers, national insurance contributions, remain unsecured. As of the 1st of December, so any insolvency that commences on the 1st of December, the Crown will have this limited preferential status. And there is no time limit on how far back the Crown can look at arrears and ascribe to them preferential status. And that's going to have quite a big impact.
So this is effectively a form of retrospective legislation.
Does have that effect.
You've been sitting there as your floating charge holder thinking you've got security for X, and all of a sudden you've got it for X minus the preferential liabilities.
Absolutely. And that's going to have a big impact, I think, on lenders' willingness to take floating charge security. Yeah,
interesting. Well, before we get into any more of the detail, does anyone on the panel think this is a good idea?
No.
No. Well, hang on. The government says it might raise 185 million in the next financial year and 195 million in the next financial year after that. At a time when the country's bankrupt, isn't this the right thing to do?
I think it makes CVAs extremely difficult because in a CVA you're compromising the unsecured creditors, and usually you need the support of the preferential and the secured creditors, and usually that support is by paying them in full. Oh. If you then have to pay in full a very large preferential claim, as David says, it's really reducing what you can offer to the unsecured. And therefore it makes the CVAs a lot more difficult. And that's probably why we're seeing a rush of them just at the moment while people try to get in before this takes effect.
Andrew, have you got a sense that people are aware of this impending deadline? Andrew, you're on mute.
The clients that I speak to, it's largely gone under the radar for them, and it's more about business survival, and a lot of them continue to tick over with the government support. So for me, it hasn't been a huge concern for the clients that I speak to.
There is one good piece of news, though, James. I think that if we're able to use the restructuring plan for SMEs and get it into a position where it's not so costly, you then would have another class of creditors that you could then put forward a plan to. And if you could get the revenue to agree to a payment plan as part of that, it might enable you to restructure the whole company. So that's kind of the only way in my head I can feel that it's a good thing in terms of restructuring. I quite agree, as a taxpayer, it's a good idea to get the money back, but if it means the companies are going to fail all over the country, that obviously isn't a good idea.
Yes, well, there's a number of issues that arise out of that. We've got the CVA problem. We've also got the potential effect on financing. I saw a statistic which UK Finance said they thought it would take £1 billion of financing away from business because of lenders' reluctance to effectively put themselves further down the chain. Has anyone got any views on that and how lenders might improve their positions?
We've certainly seen in the ABL sector that they're very concerned about the dilution of floating charge, and so they're looking more to do assignments of debt rather than relying solely on floating charge realisations from assets. And chattel asset lending is not nearly as attractive from December onwards, I would say.
I think lenders are going to want to take title to receivables, to chattels, whether by mortgage or otherwise, and that's going to make businesses much less agile if lenders are almost exercising fixed charge control, and that in turn will have a damaging effect on their ability to do business quickly and recover from the financial impact of the pandemic. And it seems to me that it would have been better to encourage that recovery rather than hamper it by giving the Crown back some preferential status.
Andrew, I think you wanted to come in then.
Yeah, I was just going to say, I think it will impact certain sectors in particular. So I think where some businesses rely on that cash flow funding, if they're the funding stock, so any kind of floating charge assets, and that's going to be a real concern for them. So whether you see lenders restrict their lending or try and exit certain sectors, that might be the case.
What about the steps that lenders can take to effectively monitor the ongoing position, because they might be happy to lend to begin with, but they might be very concerned if tax debts start to build up, and therefore their position is worsening as time goes on.
Yeah, I certainly think they're going to be very conscious of HMRC debt going forward, and would be introducing that to monitor businesses and how they're paying, submitting returns, and making sure they monitor that on an ongoing basis.
So they might be changing their covenants. So you've got to provide regular updates.
Yeah, I think so. Yeah, and internal practices and how they manage their clients, and they may well take the view with certain clients, I'd imagine, that probably don't have the compliance or don't manage their business in the way they would expect it to, that they might take a view of trying to exit from those clients.
Yeah, we're certainly seeing clients wanting to do a sort of audit of tax at the beginning, in the same way as you do a security review, you're doing a tax review, and then regular monitoring of that, because if arrears are not paid, then the position is going to get worse. Yeah.
And Katie, what about position of directors and personal guarantees? Do you think this is going to have an effect on that?
Yes, I think really we can expect more claims by lenders using existing personal guarantees as the money's available to them is reduced or even exhausted by Crown preference debts. I think some directors might be less inclined to enter into PGs as a result of it, but obviously in the current climate there'll be quite a few directors who feel like they don't have a choice, and that's the only way in which they can get their finance for their company. And I also think that needs to be considered against the backdrop of what's happening, or what has happened with the Finance Act. We're going to hear from Chris Buckley, I think, about the recent provisions which effectively can make a director or a non-director joint and severally liable for certain tax debts, as well as furlough payments that have been paid in error, or if those payments were fraudulent. So I think all of that together could effectively increase the risk of personal insolvency for directors, which is obviously quite worrying.
Yeah, you've got a pinch point, haven't you? Lenders are going to want more in the way of security from the directors, including personal guarantees, but the directors are going to realise they're under much more risk in relation to that, because the Crown will take such realisations as there are.
Exactly.
as a general point, I think Philip Hammond mentioned this as a bit of a footnote in the 2018 budget, which I think people weren't terribly thrilled about at the time. But it does seem to be difficult to justify bringing it in at this particular point when I don't know what the level of Crown debt it is, but it must run into the hundreds or millions or billions of pounds at the moment.
Yeah.
It's also got to be weighed, I think, against the amount of money that the government is spending in order to address the pandemic. And the cost alone of the furlough scheme, for example, the amounts that this is likely to bring in are in relative terms very small compared to the expenditure that is being authorised very happily. And it does seem to me, I've just seen the question from Chris Lawson, does seem to me that it is a problem that the government is taking away from other creditors who've lost money when they're at the same time prepared to spend a lot of money on good things like the furlough scheme, but also on the festival of Brexit, where £29 million might be better spent elsewhere. Political rant over.
Let's not go there yet.
Yes.
But I do think that's why. I mean, with my R3 hat on, we are speaking with the Treasury and with the Insolvency Service and with HMRC to try to work out ways in which businesses can be restructured, because that's the only realistic way that the tax is going to be paid in any significant manner. And therefore, we need HMRC and HMT to be supportive of sensible CVAs and sensible restructuring plans that can rescue good businesses and businesses that are perfectly proper and well-run businesses but have been hit by COVID, unable to trade for many weeks during the various lockdowns and restrictions, and need to restructure their debts to carry on. They need to put forward CVAs and restructuring plans to restructure and get Crown support at every level. And we'll have the Crown as a secured lender in some of those, as the CBIL or CL bill guarantor. We'll have them as a preferential creditor, and we'll have them as an unsecured. So we're really trying to engage them in actually working with the restructuring profession to save some of these businesses and be supportive in those efforts by insolvency practitioners and advisors.
Yes, I mean, if the revenue had a policy of being willing to accept, I don't know, 50% or 30% or 20% of the preferential debt as such, that might make CVAs workable. Yeah,
and I think historically they're better at payments over time, so I think they're probably more likely to go down that route. But certainly, I absolutely agree. We need to be engaging with them as a profession to understand the ways in which they could deal with their requirements at the same time as supporting the business through a restructuring process.
Yes. So we'll just look at the questions they come. Chris Lawton's out, we've dealt with that. Lisa Bricknell's asked, are lenders pricing debt differently as a result of this, or just simply preparing to lend less? It may be a bit early to know the answer to that, Alison.
Yeah, I would say potentially I think it's getting more expensive, but it's also that people are just more reluctant. There's so much uncertainty at the moment that it's another thing that means lenders are reluctant to get involved with businesses. But what we're seeing is a much more due diligence at the beginning of the process to understand the tax position of the company before a lender will even look at giving a term sheet. It's something that's really right at the top of the agenda. Okay, so we're all generally a bit negative about it, but there may be ways of using it. And Alison, I think your main point is potentially using the Crown as the under the restructuring plan to help get restructuring plans through that might not otherwise be able to be used. Yes, I think as a starting point, if one can make a sensible proposal to HMRC regarding the preferential debt and get them engaged in discussing that and comfortable with that, if you're then acting as a monitor, you're probably going to be more comfortable that you can say it's likely that the company could be rescued because you have one class of creditor that you think you have on board, and that makes it more likely that you're going to be able to get the restructuring plan through. You then start talking to the other classes of creditors, the secureds and the unsecureds, to get them on board with the plan too. And you may not need to do cross-class cram down, hopefully you don't, but you're having a different start to the conversation, having got one class on board. So in that way, I think we could use the fact, much as we don't like it as being an extra top preferential class that's diluting realisations for unsecured creditors, it does give us a starting point on the plan that could be quite useful for SMEs. Okay, I can see another couple of questions come in, but we might just park that one to the end and move on to our second topic. There's certain words that are like red meat to people. Brexit is probably one of them. Donald Trump, that's two words, is another. But one that certainly is red meat to some people, certainly in Parliament, prepacks.
And in the face of the pandemic, we've got draft prepack regulations. Katie, what's going on there? Why are these coming about?
So the government's announced its intention to regulate prepacks to connected parties. The draft regulations that they've provided actually go beyond that and cover all substantial disposals to connected parties in the first 8 weeks of administration. The government's considered banning them outright and decided that's not desirable. Similarly, it's decided it's not the best route to make referrals to the prepack pool mandatory. So what we have are these draft regulations which will require an administrator to either get creditors' approval for the sale if it's caught by the regulations, or for the connected party purchaser to obtain a report. And even if a report is obtained, the way in which the regulations are drafted are such that the administrator doesn't actually need to follow the report, he just needs to give reasons. So it obviously is something that will raise various questions for us going forward. And I wonder whether it's likely at all that the regulations will be drafted, accepted in the way in which they're drafted.
Yes, that's really helpful summary, Katie. I think the report identified improvements in behaviour. It's rather like a class report. Johnny's doing much better this term, but still not quite good enough. So therefore, we need some more measures. Andrew, this is your profession's responsibility for not complying with SIP 16 enough, not marketing, and generally not giving the public confidence in prepackaged sales. It's all your fault, isn't it?
Well, apparently. I think, I mean, SIP 16 is there. It's pretty comprehensive in what steps you have to follow, and in terms of the marketing requirements, again, are very comprehensive. I did see on some statistics that it was something like a fifth of sales go through without any marketing whatsoever. But justification was provided for not providing that marketing, and it is a difficult balance as an IP where you're trying to deal with the pre-pack and the marketing and the risk involved with marketing widely. I think the evaluator role, again, interesting that they're introducing that. I think there's been talk about IPs becoming the evaluator. And I think the comment I'd have on that is, I think we just have to be conscious that perception of people from outside the profession of whether they want independent people from outside the profession reviewing these transactions rather than IPs themselves.
Just for people who haven't yet read the draft regulations, as Katie said, the second option is to get a report from someone called an evaluator. And Regulation 9 says an individual meets the requirements as to qualification if the individual believes that they have the requisite knowledge and experience to provide the report. David, what's your view as to that provision?
I think that provision has the risk of abuse about it, because I might say I believe I have the requisite knowledge and experience to provide the report when plainly I don't. My view is that it will have to be insolvency practitioners who write these reports as evaluator, but I can see there's a degree of squeamishness and a proper degree of squeamishness about doing that, because it looks like they're just regulating their pals and saying, yeah, this is great, off you go, collect your fee. And that's always been the issue with prepacks. But I don't see, unless we have this sort of quasi-profession of evaluators, who else is sensibly qualified to do that. And I suppose there must be a way, if the individual is so obviously unqualified, of saying that in no world could they possibly have held that belief and challenge the whole thing. I can see scope for argument there, certainly.
Yes, it did seem strange. There's not even a qualification that sort of reasonably believes that they have the qualification. Alison, what kind of discussions have you had about this provision with your R3 hacker?
Yeah, so R3 is in discussions with the Insolvency Service about it, and I've just seen actually on LinkedIn they've just published their comments on their blog this morning. I mean, I think the regulation is draft, so it's likely to get amended, I think. But the key issue is, I mean, I think that SIP 16 has gone a long way to deal with external concerns about prepacks, and IPs ultimately do face potential challenges from liquidators if they're appointed to the transactions they've done, and we've seen quite a lot of litigation in this area in the last few years. So I think IPs are generally very mindful of this and getting the best deal in town. So the risk for the creditor is only if there isn't a liquidation. And one of the things we thought about at R3 was whether, if there was a connected prepack, you had to ensure that there would be a liquidation and leave enough money in the case so there could be a liquidation. But that wasn't something that was taken up in the by the insolvency service, and that would be a way where there would definitely be a check and balance on the deal. But again, to Andrew's point, it's still another insolvency practitioner who's looking at that deal, because a liquidator will be an insolvency practitioner. So we can't really get away from that point. I think we just have to make sure that the perception of this changes as far as we can by showing that it is the best deal in town. And very often with a connected prepack, it's a startup company where the directors are the only people who really know how the business works, and very little other external interest will have been received by the IP when he's tried to sell the business. So we've just got to keep going with explaining what we do, I think, because very often those deals result in the business being saved and continuing and getting to the point where they actually start to make money. Well, that's in the old days. I mean, it remains to be seen what will happen post-COVID, because obviously things are going to be an awful lot more difficult next year for all businesses.
Yes, and I think just looking at the government report, it said that, for example, they were entirely happy that 7,500 jobs had been saved as a result of prepacks during 2016, which is quite significant. And in terms of this as an issue, only 29% of administrations have prepacks, and only a third of those were regarded as involving sales below market value. So we're talking maybe 10% of all administrations.
Yeah, it's a very small part, and R3 did undertake research, which I was involved in a few years ago, which very clearly showed it does prepacks save jobs because they enable the business to transition without being tarnished by being in a formal insolvency for very long. So, and that's established by looking at data from lots of cases. So the difficulty is people don't know about it, particularly landlords. They're jumped by somebody that they aren't aware of as a new tenant. So it's all about the perception, and it's something that keeps coming up in MP's postbags. And this issue came up in the third reading of the Seeger bill in the House of Lords, and the question was asked about prepacks in the middle of the discussion on the plan and the moratorium. So it's obviously something that aerates politicians, and that's why we have to keep on trying to explain what we do and how that it's a concern relates to a very small fraction of what are a very good way of saving businesses in the UK.
Well, this one's got people going. Simon Jerem's asked a question. Katie, perhaps you want to deal with this one. Won't this just lead to purchasers shopping around for reports? If the purchaser doesn't like the first report they've got.
Well, I think as they're currently drafted, the regulations certainly permit this. Seemingly someone can canvass as many opinions as they like, and the regulations actually refer to them obtaining more than one report. So there isn't a limit as the amount of actual reports they can obtain as well. So there is a real risk.
Yes, and James Nichols has asked a question, which I think is probably one for Andrew, about effective. No, I think this is about selling businesses pre-insolvency, either with or without the sort of blessing of a voluntary liquidator who's about to come in. Have you seen that, Andrew?
Well, it has. It's been raised with me. I think what I touched on before about the marketing of a business, where it's a difficult discussion to have with the director, because there's a slight conflict there for the director in you're saying you need to market this to make sure we get fair value and test the market, but equally they have that concern that other parties will become involved. And actually what I've seen are some people saying, look, we're not comfortable with the marketing on the basis that there's a real risk to the business disintegrating if competitors become aware of it. Therefore, can we look at doing a sale in advance of a liquidation? So again, for me, that's something I think could be more common.
Yes, and there's a few questions on a common theme about the pre-pack pool continuing to play a role as an evaluator. Alison, what discussions have you had, if any, around those?
I haven't actually been involved in this Prepack thing because my focus has been on the back to business, but I understand that has been discussed. And I think another question from Suzanne also is relevant, because the key issue for me, if one's evaluating whether it's a good deal, is one has to know what the other deals are and what steps have been taken to evaluate the business. And so just looking at the actual offer by the purchaser doesn't really get you to whether it's the best deal in town. So trying to share more of that background to why this is a good deal, I think would be helpful in terms of the evaluation process.
One thing I was just going to add is actually what the prepacks I've dealt with recently, we've had more than one agent involved in the process. So it's almost ensuring you're not duplicating the cost, but you'll have one doing the evaluation, looking at marketing, and the process being ratified as well. And it just adds, that's helped with some creditor engagement and explaining them that you've got independent agents working on it to give them a bit more transparency, and that's given more comfort to them.
Yeah, I think the more external evidence you've got, the better, that's independent. The difficulty is, though, in a lot of these businesses, it's very difficult to value. So one can value certain assets more easily than others. And I would say just at the moment, it's very hard to value anything because we just don't really know what buyers are going to pay at the moment, because everybody's waiting for the bottom and the bottom never seems to come. So I think the whole process of valuation at the moment is really difficult. But at the moment, as we know, we don't have many formal insolvencies because of the temporary measures. So it isn't an issue, but it is going to become an issue as we go into next year.
David, this raises some interesting questions about duties of care, doesn't it? You've got the administrator with his duty of care to the company, who's relying on a report provided to the purchaser by another person who may well not owe any duties either to the administrator or to the company. This could be some fertile ground for prof neg litigation.
I think that's right. And I think it picks up Jonathan Whitbread's question about whether IPs will want to be an evaluator, given the extent of the risk and the likely relatively low fee they'll be able to charge for it. I think the evaluator can only really owe a duty of care to the person instructing them. So that would be the prospective purchaser. The risk here is either insurance premiums for doing this sort of work will go through the roof, or the report will be so heavily caveated that it won't really help anybody, which echoes Alison's point about whether it's possible to reach a view in the absence of proper background information. I can't imagine that the purchasing party is going to, in effect, indemnify against the risk on any sale that might take place. But I do see that this is a potential ground for professional negligence claims. But you don't want to be the evaluator who faces the first one, it seems to me.
Yes. So, perhaps we just move away from that topic. Katie, you briefly mentioned furlough fraud. This could be a potential fertile ground for more claims. You just want to give us a little bit more detail on that?
Yes, well, I think it was back in September, it was reported in the press that I think there was about £3.5 billion worth of furlough payments that had been wrongly paid, either in error or as a result of fraud. And obviously now the furlough system has been extended until March next year. So there's a chance that that number could increase significantly. What hasn't had much attention is Schedule 16 to the Finance Act, which provides that in certain conditions, directors and non-directors could be held joint and severally liable with the company for those furlough payments if they were made in error or fraudulently. So we could see that there's an increase in actions brought by the company, brought by liquidators on director's duty, other instances as well. So I think it's another area for litigation.
Yes. And I think one would imagine the government, in theory, is very interested in being properly resourced in order to be able to bring the claims under the Finance Act, which would have the advantage for them of cutting out insolvency practitioners and fees. But Alison, I'm not sure that HMRC is set up to bring many furlough fraud claims under this Act.
I'm not aware of that yet, but I'm sure they'll get to that. I think at the moment everybody's trying to sort of deal with what we're trying to do in terms of the changing legislation and getting businesses back on track and trying to collect the taxes that people haven't paid. But I'm sure they will move on to this. Again, I think it comes back to the point I made earlier, which is realizing that we need to take steps to recover funds that have been improperly obtained is kind of, I think, the next stage of the government's thought process, having actually got businesses back on track. So perhaps once the JRS ends in March, there'll be a greater focus on this sort of collection of debt due to the Crown. But I'm sure they'll get to it, and I'm sure they'll need some panels to help them with it. And it strikes me that they may need some secondees from our profession to assist with what's going to be a busy time for them in terms of dealing with restructuring matters.
Yes, and I'm sure the insolvency practitioners would equally be wanting to explain how they can deal with it in another way through directors' duties, and that may be a convenient way of doing it. It's rather nice, like the directors' disqualification legislation, where they brought it in, allowing the Crown to bring direct claims, which was sort of parallel or conflict with liquidator and office holder claims.
Yeah.
And now, before we had a couple of questions that came in before we started the debate, and I think obviously we've had the extension to the temporary measures to the 31st of December for the winding ups, and in terms of the restrictions on Part 8.1 moratoriums, the temporary measures have been extended to the 30th of March. I think a lot of people are interested in the view on the ground as to what we think is likely to happen, A, whether those dates are likely to be extended, and B, when they come to an end, whether we see something of an avalanche. Andrew, on the avalanche point, what's your ear to the ground seeing?
Well, I think the protection from petitions is the main one for me at the moment, in terms of that's because that will often trigger the insolvency, or if it's HMRC enforcement, putting pressure on a business to repay. So whether that is extended beyond the end of December will be interesting, because I think that at the moment, along with furlough, that there aren't the triggers there to make directors make the decision to go ahead with an insolvency process in quite a lot of circumstances. And that's what I'm seeing at the moment, is there are clients there that are struggling, but they won't make that decision at the moment.
Yes, and so I mean, we've got a lot of companies which, we use this phrase, zombie companies. And David, there may be a lot of companies that really should have gone into liquidation. And of course, the wrongful trading protections, subject to any retrospective extension, which I know there's been some discussion about, those expired on the 30th of September.
Yeah, I think there's a risk of wrongful trading claim, and there's also a risk of straightforward breach of duty claim on the basis that the creditor's interest duty has obviously been engaged, and by carrying on, the company has lost money. That looks like a wrongful trading claim dressed up differently, but if you can bring one of those, that makes the quantification much easier, because you don't have the comparative exercise to carry out. And that's an attractive way, I think, for IPs to seek to swell the assets of an estate by saying to the directors, you had it then, you should have stopped, and when you carried on, you don't have £150,000, whatever it is, has gone out the door because you carried on when you knew that the company could not continue. And I think that will be a source of recovery actions against directors for not having stopped soon enough, and hoping, probably against hope really, that they could resurrect their companies in the first half of next year.
Mm.
David, just to add to that, I think what I say is what I see from some clients is with the furlough money, they are not paying on the tax to HMRC. So those kind of issues post October, it's pretty clear that those companies would have known that they're trading insolvently. So whether that's wrongful trading or breach of duty, that not paying that tax over from the furlough money could be a problem for quite a lot of directors, I think.
It's sort of double whammy, isn't it? You've got your tax arrears and you've got your furlough.
Mm.
Yeah.
What do you do?
And the furlough scheme's quite clear that you're supposed to pay over things that aren't for you straight away. So I think that's quite difficult for directors. But I think we should also talk about landlords. So the landlords and suppliers in the first lockdown period who were owed arrears are now coming up to, 3/4 of a year without being able to really put proper creditor pressure on the companies. And that's becoming a pretty serious issue for them, I think, for some of them, in terms of their financial position. I don't know whether they will be extended, but my money would be on the winding up petition one being extended for a further quarter in line with the JRS extension, particularly given that Brexit actually kicks into effect on the 1st of January. So there will be uncertainty on pricing and delivery of goods and possible supply chain problems. We still don't know what the deal is. So I think the last thing the government would want at that point is a lot of winding up petitions in January, which would make it look like it was a result of Brexit. So I would be thinking it will go out a bit further in light of the second lockdown, but I think we probably won't know till the end of December, because we always seem to know just right at the last minute, but we'll have to see. But certainly I think if you're a director now and you have got rent arrears that go back to Q1 of this year, and you aren't in discussions with your landlord about reorganising your payments under your lease, you must be getting to the point where you could be in potential wrongful trading territory, because you should know, or ought to have known, that you can't do a deal in January and you don't have the money to pay. So I think it does get difficult for directors now, whereas I think earlier in the year, notwithstanding the fact the suspension of wrongful trading ended, provided they were acting in the best interest of creditors in accordance with the statutory duty, they were probably okay. Now things are getting a lot hotter in terms of potential liability, unless they are looking for advice. So this comes back to the message of my campaign, which is we all need to encourage directors to seek advice earlier and take that advice. And if they are looking at putting together a CVA now or a restructuring plan, they are going forward towards rescue, or if rescue is not possible, looking to go into administration once the temporary measures end, so that they are actually moving forward in the best interest of the creditors. And that's the message we're trying to get out to directors, to actually come and talk to IPs earlier, because it's far easier for you to rescue a company if there's still cash in the bank. And a lot of these companies still have cash in the bank because they've received furlough money and other grants from government. So there is a possibility of rescue now, but there probably won't be the more we get into Q1.
We've just got a couple of minutes left, but I think that also segues into the use of the moratorium, which, as I understand from speaking to people on the ground, has not at the moment been greatly used. Andrew, that may be because IPs have been a bit nervous about acting as monitors.
I think there's a bit of that, but I think it's largely because of the protection from petitions at the moment. So I think we'll see it more once that falls away, and it will be used as almost a bridge into another process, whether that's a CVA or a restructuring plan. So I can see it being used more, certainly in the future.
That's certainly what I hope, because I think it is a good bridge to get to a point where you can put forward a CVA proposal or a plan, or time to restructure. And at the moment, people are really struggling to put proper cash flows together because everything keeps changing. So it's very difficult to put something together that creditors can rely on. And I was speaking to an IP a few weeks ago who had just put together a CVA, but then because the second lockdown was happening, everything had completely gone up in the air again. So people are just facing these shifting sands that make it very difficult to put forward credible proposals to creditors that they will be able to accept.
And I haven't been able to deal with all the questions that have come up, and apologise to people. He's now finding that some landlords are issuing bankruptcy proceedings against directors in relation to PGs because they can't deal with the winding up petitions against the companies. And I guess that just shows the law of unintended consequences. Yeah.
I can quite see that would be, I mean, some landlords must be getting quite desperate. If they're a smaller entity, they need cash flow like anybody else. So they would be looking to use whatever means they have. And there's no protection for individuals in the same way as there is for companies at the current time.
So we've got people facing Brexit, prepack legislation, COVID, and Crown preference, and the new legislation. I mean, it really couldn't be a better time to be an insolvency lawyer, could it? I'd like to thank you all very much for your contributions, particularly Alison and Andrew for joining us. Katie, David, thank you very much as well, and for all of you for your questions and contributions. Sorry we couldn't get through all of them, but we hopefully have given you something to think about. And David, I think I'm now going to hand over to you to pass over then to the breakout sessions.
Thank you.